1244, we'll probably just march down the Kavanaugh Bridge after this next one.
Mr. Chair and members, the Strike Everything Amendment to Senate Bill 1284 relating to lifetime probation and sexual offenses prohibits a person who is on lifetime probation due to a sexual offense from petitioning the court to terminate their probation before 20 years after the date the person is placed on probation for a Class 2 or 3 felony, and 10 years after the date the person was placed on probation for a Class 4, 5, or 6 felony conviction. The Strike Everything Amendment also requires the court to place on the record before modifying or terminating a person's probation who is on probation due to a sexual offense that the court is unaware of any pending criminal charges against the person in any jurisdiction. Mr. Chair, there is one amendment to the Strike Everything Amendment that I would be happy to explain.
Yes, please.
Mr. Chair and members, the amendment sponsored in Senator Gowan's name on February 14th at 2:36 p.m. requires the probation department to complete an investigation of arrest notifications and warrant checks to determine whether a person has any current or pending criminal charges against them before recommending a modification or early termination of the person's probation sentence. The amendment also prohibits the court from issuing an order terminating or modifying a person's probation sentence if there is a current or pending criminal charge against that person. And with that, I would be happy to answer any questions.
Any questions for Katie? Thank you. All right. Senator Shamp.
Good afternoon, Mr. Chairman, committee members. I'm here to discuss my bill, Senate Bill 1284. This bill was brought to me by a constituent with concerns with what's happening on the third Friday of every month in probation court. This bill was the crafting of it was with a probation officer that takes into consideration what is going on. And basically, I'd like to read a definition. Lifetime probation is what we're talking about here, right? And we're talking about changing how that is viewed. Well, the dictionary definition of lifetime is the period of time during which an individual is alive. And unfortunately, last session, that had to be actually defined in statute. So now this is kind of a cleanup, a follow-up to that, to define the fact that if you are placed on lifetime probation, that in 3 years, probation is done. It's going to actually stipulate that based on the class, because they get pled down quite a bit, but based on the class, that there's a minimum that must be served. So for the lower class, it would be 10 years minimum to be served prior to being allowed to be dismissed off of probation. Or for the more severe sexual assault crimes. Let me make that very clear that this has to do with sexual assault. This is not Romeo and Juliet. This is crimes against minors and sexual assaults against innocent women. This will continue the probation for a minimum of 20 years for the more severe crimes. That's what the one amendment is for, has to do with the court's liaison, trying to figure out the exact language for all the people I've met in talking to probation. The court's liaison suggested that the notification portion, that's the amendment, needs to be worded so that the courts can put it on the record that they did, but they were worried that there would be some kind of punitive back towards the courts. But the courts agreed that they would be willing to verify there were no new pending charges prior to releasing anyone from probation for a crime such as this. That makes sense? I have any questions?
Yes. Senator.
Thank you, Mr. Chair. How many people are we talking about that this would affect? Do we know? I mean, do we have a ballpark?
I don't have that figure for you.
Okay, Mr. Chair. Yes. I only asked because I wonder if we had probation officers that shadowed us last week, and I learned a lot about the probation department here in Maricopa County, and I just wonder if there's a cost associated with, I mean, if it's a significant number, if that's gonna, if we need to hire more probation officers, or the counties would have to hire more probation officers. I don't know how that works exactly.
Senator?
Mr. Chairman, Senator Fernandez, I don't know exactly what the cost would be because I don't know the amount. But as a woman, I'm going to look at that and say, well, whether there's a cost involved in it or not, if someone is placed on lifetime probation, I'm the victim. I would think that lifetime means lifetime. So 10 and 20 actually is. I would think that that would be involved in the conversation when we're talking about lifetime probation as far as fiscal responsibility by the state. But they do actually pay for probation as well, correct?
I don't know the answer to that one, do they? Okay.
There
Then
are
that's-
fees associated with it, yes, sir.
Okay. Sure, then that's okay. Thank you.
Senator, okay. Any other questions? Thank you.
Okay, thank you very much.
Mr. Vice Chair?
Mr. Chairman, we have 4 people signed up to speak. Donna Ham, then Vicky Compo, then Catherine Craigsey, and then Kaylee Kozak. Please state your name for the record, and you'll have 2 minutes.
Thank you, Mr. Chairman and members.
Please pull the mic right up to your,
My name is Donna Ham with Middle Ground Prison Reform. This is my 40th year here at the legislature, thus, I guess. We oppose the striker to this bill, 1284. This bill proposes putting a mandatory minimum, if you will, on the time when an offender can be considered to be trusted, redeemed, if you will, to maintain a lifestyle and behavior that comports with the law in all respects. Judges are in a much better position and are much better equipped to make these decisions. And there is no benefit to be gained by placing an arbitrary amount of time on every single case because people are different, they progress differently, the facts of their crimes are different, and their life experience is different, which led them to commit certain crimes. From our experience in assisting many sex offenders on probation, we know that most are not even considered for termination until they have done 8 to 10 years of a nearly spotless record on probation. They have to have complied with all rules along with reaching full completion of all therapy and counseling programs. We know that judges do not issue termination of lifetime probation easily. Probation officers have full opportunity at any hearing to share their views and their positions on each individual offender. No one is ever automatically discharged from lifetime supervision without a hearing before a judge. Please allow our judges to do their jobs. They are better equipped and more thoroughly informed about each individual offender than anyone else. We could support this amendment if it dealt only with the requirement that the court could not terminate lifetime probation without placing on the record that the court is unaware of any pending criminal charges against the petitioner in any jurisdiction. The purpose of probation, which is given in lieu of a sentence, is to provide hope. Hope to the offender that someday he can prove with his behavior, therapy, and recovery that rehabilitation has occurred. And this redemption comes in the form of trust by informed decision makers that he no longer requires supervision in order to function as a law-abiding citizen in the community. And this is when a judge can justifiably consider early termination of lifetime supervision. I'd be happy to answer any questions.
Any question for Ms. Ham?
Mr. Chair?
Yes,
Thank you,
Senator.
Mr. Chair. Thank you for being here today. I got lost just in the middle towards the end a little bit. Do you feel as though there is an amendment that would make this more acceptable to you, or do you feel like you have no support for this?
Mr.
Ham.
Chairman, Senator, we believe that I believe it's the last paragraph in the amendment which discusses only the part, it's beginning with line 17 through 21, and the only objection we would have to that is that a court may not modify the person's probation before checking and placing whether they have criminal charges. And the reason for that is because sometimes a judge may need to adjust a probationer's terms, or may want to consider increasing or extending the probation because of a criminal history. And so we just are saying that we would agree to an amendment to this bill only if the order is, or the law says that in order to terminate lifetime probation, a person's probation, the judge must check to find out if there is a criminal charge pending in order to terminate the probation.
Thank
I
you.
don't know if that answers your question.
Thank you. Any other questions? Thank you, Ms. Ham.
Thank you, Mr. Chair.
Mr. Chairman, next we have Vicky Compo, then Catherine, then Kaylee, and then Patricia Border or Borden. Can't remember, can't read the last name. Please state your name
Chair.
for the record.
May I hand out these materials to the committee?
If
Thank
you'd
you
state
so
your name
much.
for the record, and you'll have 2 minutes.
Chairman Goen and members of the committee, my name is Vicki Campo, and I work with Arizonans for Rational Sex Offense Laws, speaking on my own behalf. I am speaking to oppose SB 1284 because it takes decisions out of the hands of judges and imposes arbitrary mandatory minimums with no evidence that doing so would improve public safety. In fact, the handout I've just given you lists 14 separate studies that show that sex offender recidivism is in the single digits, less than 10%. For other crimes, it's roughly 67%. AZRSOL is the only group in Arizona that provides support and advocacy for those living on the registry, and we see the collateral consequences of laws like SB 1284 as our criminal legal system continues to cast a wider and wider net. Many who are caught up pose no danger to our community. Currently, most people on lifetime probation must successfully serve 7 to 10 years or more without problems and in full compliance, as Ms. Ham said, and before a court will consider early termination. And during this time, the probationer must complete several years of therapy, which includes a sex history polygraph, an ABLE assessment to determine pedophilic tendencies, regular maintenance polygraphs, a comprehensive risk assessment, and a community safety plan, among other things. All this provides judges with the information they need to determine whether the individual is responding to therapy and following the law. This judicial discretion is critical, since many people are placed on the registry for crimes committed as juveniles or for low-risk statutory offenses. They are not predatory and never have been. Judges are in the best position to determine if and when a person should be released from the obligations of community supervision, and placing a mandatory minimum on lifetime probation is counter to the goals of rehabilitation and redemption, which are the foundation of probation and the ultimate goal of our criminal legal system. Please, let's not widen the net yet again. I urge you to vote no on this bill, and I can take questions.
Ms. Campo, any questions? Thank you.
Catherine, then Kaylee, and then Patricia. If you'd state your name for the record, and you'll have 2 minutes.
Thank you.
And that adjusts up and down for your convenience.
Thank you, Chairman and the committee. My name is Catherine Kretschy. I am here on behalf of myself, and I'm a member of the Arizona Attorneys for Criminal Justice. Also, in my line of work, I am a public defender. I represent people who are part of this sex offender modification calendar, where they're petitioning either to modify or ask to be removed from lifetime probation. So it's my kind of 10-second spiel is I do not support this. It's bad for us financially, it's bad for us community safety-wise, and it takes away judicial discretion. The current process of how it works is a probationer will petition to get off early termination. The court then seeks the input of probation. As part of that input, probation does check and will inform the court if there are any outstanding warrants. Other cases, right? No one's going to be early terminated if they have outstanding cases, and it wouldn't be appropriate to do so. And they also seek input from the state, and there's also victim notification, because that's an also important part of this process to make sure the victim knows what's happening and has a voice at this table. If we pass this, this will impact people who were juveniles at the time of their offense. They were juveniles at the time of their offense, but there was no disclosure that happened until they were over the age of 18. Those cases are charged as Class 2 and Class 3 felonies. That would be a sex conduct with a minor. That would be a molestation of a child. For someone who was, say, 15 with a 14 or a 13-year-old, those people would be impacted by this 20-year thing, which means that we're going to have someone who was a juvenile and acted completely inappropriately, made horrible decisions, did something that's not excusable, but we are going to be monitoring them in the community until they're 40 years old. That's very expensive. This kind of probation is very expensive. They have not only a probation officer, but they have a surveillance officer. So we're paying 2 people to surveil 1 person, and these caseloads are already very high. My concern is if we don't get the lowest risk people off of probation, the people who are higher risk are going to fall through the cracks, and we're not going to have the resources to continue to supervise them in the community. We also are going to, in supervising someone for 20 years, this also has a detrimental effect to people who may be on lifetime probation for something they did when they were a juvenile, but they pled down to a child abuse with sexual motivation. This would require them to be on probation for a minimum of 10 years. That would be under the 4, 5, and 6, whereas someone else and that person for the child abuse with sexual motivation may not have been required to register because the county attorney felt, based on their risk assessment they were provided, that they were a lower risk, didn't mandate registration, whereas someone else who is deemed by the county attorney to be a higher risk and has to plead to a 4, 5, or 6, or even a 2 or a 3, and is subject to the 13-923 hearings, it's going to have this detrimental effect. It's also not going to incentivize probationers and people to complete treatment early on in their probation period. If they know they're going to have to be on for a minimum of 20 years, we're going to have people in the community who are untreated, which is not safe for any of us. It's not going to motivate anyone to do the sex offender treatment if available in prison, because they're not going to have any motivation if they know they're going to have to be on probation for 20 years. And we want people treated in the community because we don't want sexual abuse. I'm available for any questions.
Any questions? Thank you.
Kaylee Kozak, and then Patricia. Please state your name for the record, that you can adjust the podium up or down, and you'll have 2 minutes.
Thank you. Kaylee Kozak. Good afternoon, members. I was 14 years old in 2006 when I turned in the man who had been sexually abusing me. My parents accepted a plea deal on my behalf that consisted of my abuser spending 6 months in jail and serving 2 terms of lifetime probation, in lieu of spending 25 years in prison, per his request. 8 years after he was prosecuted and began probation, my abuser petitioned the court for early termination. Although I was opted in for victims' rights, Maricopa County Adult Probation Department never notified me. 5 years later, he petitioned again. The probation department did notify me this time. My abuser's second petition for early termination was denied despite a vague and uneducated recommendation from a probation officer. Monthly in Maricopa County, sex offenders who are granted hearings for their termination requests attend court and plead to have their lifetime grants terminated. That hearing is this Friday. My parents nor I were ever told that when we agreed to this plea agreement, that there was an option for him to be relieved of his lifetime sentence. When these plea agreements are being created, offered, and accepted by the prosecutor and the Superior Court, myself and many other victims of sexual abuse are being misled in that their perpetrator will be supervised forever by probation because they agreed to a lifetime. The term lifetime probation is being carelessly thrown around, impacting victims and their families. It is misleading. My abuser has petitioned 3 times in 5 years and continued to drag me through hell to have his lifetime probation grant lifted. A sexual offender can petition any time to get off lifetime probation. This is making a mockery in our judicial system. It's re-traumatizing victims, and when offenders do this, it should tell us that they are more worried about getting off probation than they are ensuring they will never reoffend. Once an offender completes sex offender treatment, they must be able to demonstrate over a significant amount of time that they have internalized the tools that they have used in order for society, the courts, and victims to be more assured that they are significantly less risk to reoffend and that children as well as potential victims are safe. I've asked Maricopa County Adult Probation Department for stats for early termination for sexual offenders and have been told no such stats exist. This bill would ensure that there is a minimum amount of time that must be served on probation supervision before an offender is able to be considered for release from their so-called lifetime probation. This is the agreement that they made with the court in order to avoid prison time. On behalf of myself and every other victim, I ask that you please support this bill. Thank you.
Thank you. Any questions? Senator.
Yes, thank you, Mr. Chair. And Ms. Kaylee? Kaylee? This has been a long battle for you. We've gotten a little bit down here and there every once in a while. And can you expound more on your whole experience on just how difficult the courts have been on pushback?
Absolutely. Mr. Chair, Senator Burley, the reason that I'm in this battle is because I am a survivor of childhood sexual abuse. And in 2020, my world was turned upside down when I was notified that my abuser was petitioning to have his 2 terms of lifetime probation lifted. Never in a million years did I think I'd get that phone call. Unfortunately, I learned that there is no definition for lifetime. It's up to the discretion of the court and probation. And probation themselves are petitioning for offenders to get off. As was stated before, they are understaffed like most. It's very insulting to me that finances and money is more of a concern, or maybe more of a concern than victims. It's also frustrating that lifetime does not mean lifetime. I don't understand why that is so carelessly thrown around. I was never told there was an option. My parents would have never agreed to a plea agreement if they knew that there was a chance that I would have to reface this man after 15 years. That is why in Kaylee's law, which provides victims and survivors of sexual abuse, we had to add natural in front of the word lifetime because we had to ensure that there was no loophole available and that victims were in fact protected for their natural lifetime.
One more
Yes, sir.
question. Yes, sir. Yes, Mr. Chairman, Kaylee. And through this process, this person's on probation. Do you know where his whereabouts is so you can protect yourself?
Goes that.
Mr. Chair, Senator Borelli, to a certain extent, yes, I am aware of where he lives just because of my victim's rights. I don't have any further, really, any detailed information. I do know that probation is overworked and there has been proof and evidence of offenders violating their probation, and rather than holding these offenders accountable, and this is what they're doing while they're on probation, they're just letting them continue with their behavior. I do have basic information. I don't go looking. It's just what's provided to me through my victim's rights.
Thank you.
Any other questions?
Thank you so
Thank you.
much.
Patricia? If you'd state your name for the record.
Yes.
You'd state your name for the record.
I'm Patricia Borden. I'm the Director of Arizonans for Rational Sex Offense Laws, and I thank the chairman and members of the committee to allow me to speak. My heart goes out to any victims, to this victim here, but I have to tell you that through our work of almost 14 years now, we've spoken to a lot of victims, and all victims don't feel the same. The Arizona Coalition Against Sexual and Domestic Violence have sided with us many times on some bills because families want to reunify with each other. But I've handed out this brochure which highlights that there are zero scientific scholarly studies demonstrating that sex offense registries or lifetime probation make our community safer. Maricopa County Adult Probation works with probationers who meet certain criteria to get off lifetime probation, as is that it's unsustainable both financially and in terms of for staffing to monitor the number of people receiving lifetime probation sentences. Yet, as of this morning, I was surprised to learn that Cynthia Stevens, Maricopa County Adult Probation Sex Offender Division Director, is unaware of this bill. Currently, probationers are incentivized to actively participate in treatment and become productive members of society. The proposed change would be a move in the opposite direction. It's an additional and unnecessary burden that assumes the Arizona legislature knows better than probation officers, psychologists, and judges. According to the Maricopa County Probation website, they state, research has proven that if defendants and probationers make needed changes in the most critical risk and needs areas, including relationships, thoughts, and beliefs, they will have a lower risk to reoffend, thereby making the community safe. At a time when the American Law Institute, all research and public opinion are recommending lessening restrictions, I urge you to vote no on SB 1284.
Thank you. Any questions? Thank you.
Mr. Chairman, that's the last of the speakers
All
we
right.
have.
Well, let's move a bill.
I move SB 1284 with a due pass recommendation, and I move the 21-line Gowan strike everything amendment dated February 8th, 2023 at 11:21 a.m. be adopted, and I move the 8-line Gowan amendment dated February 14th, 2023 at 2:36 p.m. to the strike everything amendment be adopted.
All right, members, you've heard that motion. Those in favor vote aye.
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 Those opposed, nay. Appears the ayes have it, do have it, so ordered. Mr. Vice Chair.
I move the strike everything amendment as amended be adopted.
All right, members, you heard that motion. Madam Secretary. No. We have a voice vote. One more? All right, I am sorry. So you've heard the motion. Those in favor vote aye.
Aye.
Those opposed, nay. Appears the ayes have it, do have it, so ordered. Mr. Vice Chair.
I
it as
move
amended.
SB 1284 as amended receive a due pass recommendation.
All right, members, you've heard that motion. Madam Secretary.
Aye.
Pass.
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 Aye.
Mr. Chair, may I explain my vote?
Yes.
I'm very sympathetic to the concerns that the sponsor has and what's trying to be addressed here. I agree with many of the opposition voices that there might be some unintended consequences and that there are several problems here. I would like an opportunity to work with the sponsor and with some of these opposition voices to see if there's a way to improve this. And for the time being and to continue that conversation, I vote aye.
Aye.
Mr. Chair,
Yes.
I agree with Senator Birch. I think Intuitively, I'm someone that believes that judges should have some level of discretion over these kind of matters, but I do want to work with the sponsor and see if there's some things that we can do. I vote aye.
Nay.
Aye. All right, members, 6 ayes, 1 nay, 0 not voting. You've given Senate Bill 1284 as amended due pass recommendation.